depends on what the parties agree upon. If there's no lease, then the landlord can make any deal he wants. A weekly tenant gets a weekly notice, a monthly tenant gets a monthly notice, a yearly tenant gets a yearly notice. So there you go.
It's up to the parties. And of course, to our viewers at home, if you have any questions regarding buying or selling a home, buying a condo, which is something very popular now, or leasing in a residential or commercial context, give us a call at 416-446-7090. Now, back to the whole relationship between the landlord and tenant. Either of you can take this. What is the main difference between the residential sector and the commercial sector?
Well, since the statute applies, Bob, you answer the first one.
Residential is highly, highly regulated, and
the commercial lease governs the relationship between a landlord and a tenant. So both statutes apply, but residential is residential, and commercial is commercial. They're entirely different entities.
There's almost no regulation on commercial. There's no rent control. You don't have to get a court order for eviction.
Well, let's talk about the eviction process in the residential and then also the commercial process in the commercial sector. So what would the process be if someone's getting evicted? Frequently, I used to work at Parkdale in the landlord and tenant division, and you would have people coming up to you saying, I'm getting evicted. They're kicking me out. I either have a notice or none at all. I know there are a lot of steps that go behind it, but generally, what has to happen before someone or sheriff can be at the doors locking them out? Commercial.
Well, commercial.
Okay, we'll go commercial and residential.
Usually the lease provides for the notice to be given by a landlord. Some I've seen no notice. I've seen 2 days notice, 5 days notice, 10 days notice. What happens is the landlord has to, if it's rent, the landlord has to give the notice.
For how many days? 5 days?
It depends what the lease says. Everything depends on what the lease says. If it's 5 days notice, it's got to give the 5 days notice. And then what the landlord can do, it can simply terminate the lease. Failure to pay, the landlord gives so many days notice, you got to pay it, you don't pay it, you can terminate the lease.
And lock you out the next day?
Well, there is a relief from forfeiture. In other words, what happens, a tenant can make an application to the court and say, hello, I'm sorry, I made a mistake, please put me back in. Generally, in Ontario, the courts will do that. They'll bend over backwards for a tenant the first time around and say, okay, pay it up, pay whatever costs there are, and we'll put you back in. But generally what should happen then for a landlord is ask the court to say an order saying, look, okay, you put him back the first time, but give me the order, not the second time.
Ah, I see. So the eviction process, again, it's very much so contractually driven. The landlord can kick you out a lot faster than I would assume in the residential sector. And what would that be like, Bob, under the Residential Tenancies Act?
Well, in your legal training, you knew that you got to go to the landlord has to give notice, then has to apply, has to go to the landlord and tenant board, tenant delays it, tenant appeals it, the sheriff takes all kinds of time to do it, and it takes 2-3 months, maybe 4 months, and it's a long, arduous process for both sides, and it doesn't work very well. The landlord and tenant board is backlogged. Their reasons are inconsistent. They don't publish their reasons. They don't publish all their reasons. It's the Wild West, and it's really not fair to both sides, but it takes a long time to kick out a residential tenant. And we've seen in the Toronto Star recently that woman who was actually sent to jail for lying to landlords and for being a serial bad tenant from one landlord to another.
She was thrown into jail, and what?
Well, because
grounds?
she lied about her. She lied about who she was and how she was going to pay the rent and all that stuff.
Of course, to our viewers at home, if you're a tenant or perhaps a landlord that needs a little bit of help in either the commercial or residential context, or if you're buying or selling a home, give us a call, 416-446-7090. We are happy to help you. Now, in that scenario, and then we'll go commercial, residential again, is there any way that a landlord could say, look, tenant, I know this is probably allowed in the commercial sector, but in the residential sector, I can kick you out. Let's agree that I can kick you out after 5 days if you don't pay your rent. Would that be upheld?
Residential?
Residential, and then we'll talk about commercial.
No.
Commercial it would be.
Commercial it would be.
If you put it in a lease, sure.
Absolutely, but residential it wouldn't be. any agreement that's contrary to the legislation that reduces the tenant's rights that are set out in the legislation wouldn't be enforced.
Are there any certain terms in the Commercial Tenancies Act that would also be as such, where there are certain, it's a floor that someone cannot contract out of?
Well, in regard to rent, again, the basic issues are important to a tenant. At the very outset in the lease, the tenant should put in that, one, it's entitled to notice, it's entitled to so many days' notice, at which it can respond, okay? And again, there is, even if they're thrown out, there is a right to relief from forfeiture, which depends on the court deciding whether to put that tenant back in on terms or not.
But then you got to get a lawyer.
Yes.
Got to pay a lawyer's fees.
That's right.
And it gets expensive and time-consuming.
What's one way? Sorry, go ahead.
Natasha, I was going to say there is a difference. You've mentioned termination, but there is a difference if the tenant is owed rent and the landlord puts in a bailiff to distrain a tenant's goods.
What's the difference?
The distraint is a right to seize the tenant's goods, chattels, and inventory for outstanding rent.
Okay.
And that's the only way you can distrain. And the only thing I can do is refer you to my book on distress.
Yes.
Because it's loaded with all kinds of comments as to when you can do it, how you can do it. And the bottom line for that is same way as use a knowledgeable lawyer, use a knowledgeable bailiff.
To actually distrain the property.
If you're a landlord.
If you're a landlord, that's right. If you're a
Well,
landlord.
what about in the residential context? Can someone come in and distrain your property?
No, distraint is another word for seizure.
Yep.
Landlord cannot seize your goods.
Ever.
Ever.
That's part of the act.
It's in the legislation.
It's part of the Tenancy Act.
Now, the flip side is, and I've had it happen to me, what happens if a tenant leaves all their stuff in the unit? Landlord can't take this stuff.
How long do they have to hold on to it?
Well,
for
landlord's probably got to
perpetuity?
put it in storage for a while until maybe the tenant comes back.
Same in the commercial sector?
Well,
No.
no, I've just finished. We just completed a book on the what's it called? The relief?
Relief from forfeiture?
No, the. I'll think of it in a second. I just did a new book on that. What happens is a lot of landlords, Bob is right, get scared because they terminate the tenant's lease. There's loads of stuff left in the premises. They write the tenant doesn't do anything about it, and the landlord then says he's worried because if he throws the stuff out, he could get sued. Who knows?
Why would he get sued?
If there's a Ming vase or vase in there, you know? So what he
For
does...
not selling it for the right price.
That's right.
So
Anyway,
in
so
that
there is a definite statute that covers that particular position. The landlord hires an individual, professional, who can then sell the stuff under certain circumstances.
And that's something that would not necessarily apply in the residential sector. You're saying that you have to just hold on to it forever?
I once had a tenant leave and left everything. It was like they walked out, the food in the fridge, the baby clothes, everything, and never heard from them. So I stored the stuff for a while. And after 2 or 3 months, I was tired of paying, I'm a landlord, I was tired of paying storage and insurance. And I just called Goodwill and I said, do you want to come and empty out this storage bin?
But what would have been your liability should they have come, let's say, year 4 and said, I want my stuff back?
Well, month 4.
Pardon?
I stored it for 3 months.
3 months?
Yeah. I don't think a court would have held me responsible after 3 months storing the stuff.
It's tricky, though.
It is tricky.
It's tricky, and they're very concerned. It's not like the old days. The old days, they used to take the stuff and hoof it out. They've written the tenant, they've written once or twice, and said, "Come and get your stuff," and they don't come and get it. So the landlords are very worried. What's in that stuff?
Absolutely. Well, I think there's something that we should talk about too, is when the stuff is not necessarily that of the tenants. They don't have rightful ownership to it, and that could be very problematic, or if they owe taxes.
That's true.
Or if there's a bank loan against the contents and the inventory.
Well, what would happen there? So let's say you're a landlord and someone isn't paying rent, and you decide to go the route of distraining or seizing the property, and you seize it.
Well, there's certain things you can seize and certain things you can't seize. You can only seize goods, chattels, and inventory of the tenant. You cannot seize fixtures.
Trade fixtures?
Trade fixtures, items that are attached to and form part of the premises.
Right.
You cannot seize those. And there are also, if I'm not mistaken, the statutory prohibitions about certain things you can seize and can't seize.
But if you seize the inventory, 10,000 pounds of laundry soap, for example, and the bank has a lien against the laundry soap,
Where do you rank?
You can't sell the laundry soap if the bank has a prior right to it. So it may not be the tenants or the landlord, the tenants to own and the landlords to sell.
Yeah. You can't distrain goods that don't belong to the tenant.
Or that they belong and that there's a lien against them for a bank.
Or what if they're leasing it from somebody?
You can't seize it.
Can't seize it either.
A typical example is a restaurant that has coolers that say, I won't say Coca-Cola on air, but often it has the name of a pop company.
Yep.
You can't seize that because it doesn't belong to the tenant.
How would a landlord figure that out?
It's called a conditional sale. What happens is the tenant has signed an agreement whereby he says, it's not mine, it's yours.
Yeah.
I'll use it, but if I have to give it back, I got to give it back. And what happens generally is when there is a seizure by a landlord, the landlord's got to be careful too, because Bob is right. After he does all the seizure, he gets a dozen notices from various manufacturers or various people who have put stuff on conditional sale. He says, I want my stuff back. The landlord then has to be very careful in terms of getting proof that it doesn't belong to the tenant. It belongs to the owner.
Yes, and of course, to our viewers at home, this is a lot of confusing stuff. If you need any help with respect to buying or selling a home, leasing a commercial space, or if you are in some trouble in the landlord or tenant context with respect to residential leases, please give us a call at 416-446-7090. We are here to help. Now, with respect to the eviction process, we've covered a lot of that ground right now. But one thing that I want to talk about is now shifting a little bit over to subletting and assignments. I know that you're allowed to do that in both the residential and commercial context. Different rights and responsibilities. I first want to understand in the residential sector, can you sublet your place as a tenant or assign your lease as a tenant? Do you need any landlord approval for that?
As a residential tenant, you can only assign with the landlord approval.
Can you contract out of that?
Well, you can try, but the law is the law.
Right.
Yeah, I don't think so.
The problem is that one day a landlord wakes up and says, who are you guys paying me rent? Where did you come from? And if you've got a fait accompli and you got new tenants in there, you, I suppose, have the right to kick them out.
Do you? So
because they're not your tenants. They're somebody else's tenants.
In a sublet, you're accepting the money, though. You're accepting the money. Maybe you're even responding to them, but you're not really realizing there's a different tenant in there at this point.
That's right.
So what would happen in that outcome?
Well, there would be a dispute, and it would be up to the tribunal to say, well, we're going to evict these people, even if the landlord for a month or two just accepted rent from them.
Well, what's the difference between an assignment and a subletting scenario?
An assignment is a transfer of all right, title, and interest that the tenant has in the premises.
Okay.
A sublease is a transfer of part of the premises for a particular period of time, usually less 1 day. Could be a week, it could be a year.
Of the term of the lease.
Of the term of the lease, okay? But the subtenant has to be very careful, because if the sublease includes the last day or the last week, then it's not a sublease at all. It's an assignment of the lease,
yes,
which may be exactly what the landlord does not want.
Why wouldn't the landlord want that?
Because he wants a sublease. He wants to, if there's a default, then he wants to go against the original tenant. Okay?
Why is that if there's another tenant in place?
Because the other tenant that's in place, the subtenant, may not be as financially viable as the tenant.
Well, in the commercial sector, let's say your lease is silent on assignments and subletting, that says nothing, and me, a tenant, I decide that my business isn't doing so great. I need to sublet this place out. It's costing me too much money. Can I just go ahead and do it or assign it?
Yes, you can. If the lease is absolutely silent about assignment or subletting, which is rare, then yes, there would be no control on it.
And you can sign it away.
By the way, you asked another particular point. In commercial leasing, there are a number of criteria. In other words, normally the Commercial Tenancies Act says if you need the landlord's consent, it is not to be unreasonably withheld. Okay, but what happens if it says which consent may be arbitrarily withheld, may not be arbitrarily withheld? Okay, there's case law which no one can find. It's called the Silver case. It's in all my books, but it's a court of appeal, and it says arbitrarily is not the same as reasonably, and they turned the thing completely around and said it really means which consent will not be unreasonably withheld. No one can find the case. We've looked high and low for years, but that's it.
And what does that mean? So does it mean the landlord, what would be reasonable? What's reasonably withheld?
Well, there are criteria in terms of financial worth. Have you had experience? What kind of tenant? What are you operating? Everything that you would ask under normal business